Mr. Gilbreath, any additional evidence or witnesses?
Just myself on attorney's fees.
All right. Do you raise your right hand? Do you solemnly swear or affirm that the testimony you give here will be the truth, the whole truth, and nothing but the truth?
I do. So my name is Jake Gilbreath. I've been licensed to practice law in the state of Texas since 2009. I've done nothing but family law during my career. I'm board certified in family law and have been since January of 2015. I'm familiar with the rates that are customarily charged by family law attorneys for this type of matter in Central Texas. And I would testify that the rates that appear on my invoices are reasonable, necessary, and customary in this jurisdiction. And I'll go through invoices in a second, but I bill at a rate of $6.50 an hour. My associates bill between $3.25 and $3.50. Mr. Wallace, for example, bills at a rate of $3.25. The associate prior at the beginning of this, the initial CS would be at $3.25 as well. That's an associate attorney. We try to have associate attorneys obviously do most of the work and under review, of course, but it's primarily associate charges that are on the invoices. My invoices are uploaded into the box and pre-marked as Petitioners Exhibit 3, and I'd offer Petitioners 3.
And Your Honor, the only invoices that we were provided were invoices from November 2021 through February 2022.
I don't think that's accurate, but I will just offer through that time date that Ms. Kinsler referenced.
Any other objections to P3?
No, Your Honor.
All right, P3 through February of 2022 is admitted.
And the
Mr.
reason I do
Gilbreath?
that, I'm sorry.
I'm
Yes,
sorry,
ma'am.
before you go on, just so I understand this exhibit, is what you have currently in box what is admitted, or will you need to submit a revised P3?
I guess that's up to the court. I could just say, looking at it, offer through, I'm sorry, Ms. Kinsler, the date.
It would be page 1 through 6 is what was previously provided.
Thank you for
Then
the
I just-
clarification.
And the reason I do that rather than dig and look into that is because ultimately Ms. Mitchum's position is not, I get to ask for the modification and ask for attorney's fees, right? She's asking for the change. I think she said through my opening statement, I think she said through her testimony, and she's saying through my testimony right now that she thinks it's a good faith dispute on both sides. Obviously, Mr. Hendricks does not want to see a move, no different than he wants to see a move to Lago Vista or see a move to Elgin, where she testified in her deposition that she used the word inevitable. It's inevitable that there's going to be a move. Having said that, she gets, and I get, why it's a difficult thing, and if not a difficult thing to agree to. And so she doesn't view it as he's in bad faith for not agreeing to the modification. It's a difficult decision. It's a difficult situation for these parents. And I appreciate Ms. Kinsler saying her opening that there is a material and substantial change, but it's a best interest issue at the end of the day. I do want to address two things in my testimony. One, the enforcement. The enforcement was filed, and Mr. Hendricks, like Ms. Mitchum testified to, trued up with some payments. There's, just like he testified to, there's some positions of, well, technically I didn't agree to that through our family wizard, so technically I don't have to pay for it. And Ms. Mitchum decided not to pursue that. It's not in our proposed disposition of issues. The discovery in this case all has to do with the move, with financials, with the trust, which leads me to the discovery, which has been a frustration for the amount of time and fees that have been expended on this, and sort of go through our frustration, what is in evidence as Petitioners 58, and it's the same frustration I said with with Judge De La Yata, which is, this is what we have. I mean, it's no different than when my client was cross-examined and said, well, look at these withdrawals from this trust. Like, Yeah, she's a beneficiary. She's not the trustee. She does not control that. She doesn't control the payments for the wrapping up of the estate. She doesn't control the payments made for her brother. And then so that kind of line across examination was very similar to what the discovery was of, well, why don't you should have all these information, which is why we wrote and said, we are the beneficiary of the trustee, of the trust. There's only so much that she can access. You need to talk to the trust. A lot of this has to do with Thomas Mitchum. We don't have control of that. And so the discovery has been frustrating. There's never been an order on a compel. The motion that they filed, when they filed a motion to compel, they filed it even after I wrote petitioners 58 explaining that there's nothing more. And then the morning of the continuance, they filed a motion to compel just a few weeks before trial, which caused an increase in fees, and I think made it more difficult than it needed to be. Having said all that, the case has moved forward as efficiently as it can, and that's has a lot to do with the attorneys and Ms. Kinsler involved and everybody working together, exchanging exhibits, making sure that calendars work, scheduling depositions, and so it hasn't been. It's obviously an expensive process, but it hasn't been an inefficient process. With that, I would pass myself.
No further questions.
All right.